अच्छा sorry guys, whoever are interested in preparing for judicial services could also send your number and name, and whether you are first generation lawyers or second generation lawyers. Okay, this detail. आप समझ रहे हैं हम क्या कह रहे हैं? जो लोग भी अब जुडिशियल सर्विसेज के प्रिपरेशन में इंटरेस्टेड हैं, है ना, तो वो लोग थोड़ा अपना नाम और अपने पिताजी का नाम और कहाँ प्रैक्टिस करते हैं, है ना, ये चीज़ ज़रूर हमें भेज दें। मेरा नंबर नोट कर लें, 8210435619। ठीक है, जो लोग भी जुडिशियल सर्विसेज के लिए इंटरेस्टेड हैं वो लोग, सो दैट अभी इमीडिएटली तो नहीं, लेकिन बहुत जल्दी ही हम लोग प्लान करेंगे कुछ। और कल जो है, हो सकता है कि एक सेशन हो जिसमें ये समझाया जाए कि जुडिशियल सर्विसेज का तैयारी कैसे किया जाता है। तो हम लोग उन्हीं लोगों को लिमिटेड वे में भेजेंगे लिंक, है ना, ताकि जो जुडिशियल सर्विसेज का तैयारी नहीं करने वाले हैं वो लोग इसमें फिर ज्वाइन करने का जरूरत नहीं है। तो लिमिटेड लिंक भेजा जाएगा। ठीक है, आर यू गाइस गेटिंग माय पॉइंट? हेलो?
यस सर।
यस सर।
ओके,
यस सर।
ओके,
यस सर।
ठीक 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 है, ठीक है। और हम लोग थोड़ा सा इसको ज़्यादा स्ट्रक्चर अप करने का कोशिश कर रहे हैं, ज़्यादा स्ट्रक्चर्ड रहेगा। कुछ और लोग हम लोगों को मदद करेंगे इसमें, खास करके मैडम हैं, हाँ, और लोग हैं। तो विल सी हाउ बेस्ट टू अप्रोच इट। ठीक है। अच्छा, एक चीज़ और है, वी हैड अ सेशन ऑन कंज्यूमर प्रोटेक्शन लॉज सम टाइम बैक। हाउ मेनी ऑफ यू अटेंडेड? कंज्यूमर प्रोटेक्शन लॉज का जो सेशन हुआ था, कितने लोग अटेंड किए थे आप लोगों में से?
सर आई अटेंडेड किया था सर।
ओके,
अटेंडेंस सर।
ओके, और 6-7 लोग अटेंड किए थे। ओके, तो उसका जो है वो कंक्लूड करना ज़रूरी है, क्योंकि उसमें कुछ बहुत सिंपल सा चीज़ जो है उसका वाला कभी हम सेशन रख देंगे तो सारा रिवाइज हो जाएगा। रिवीजन कम कंक्लूजन सेशन एक रख देंगे उसका, है ना, बिकॉज दैट इज वन ऑफ द my phone number. Some people want me to repeat my phone, 8210435619, 8210435619। इस अपना नाम, पापा का नाम, कहाँ रहते हैं, है ना, और कहाँ के लॉ स्टूडेंट हैं या कहाँ के, मतलब कहाँ प्रैक्टिस करते हैं। ठीक है,
एक्सक्यूज मी सर, प्लीज रिपीट कीजिए एक बार फिर से।
अपना नाम दे दीजिएगा।
नहीं ना, अपना फोन नंबर सर।
8210435619, और अपने दोस्तों में सर्कुलेट कर दीजिएगा, क्योंकि ज़्यादा लोग रहेगा तो आसान रहेगा हम लोगों के लिए ऑर्गेनाइज करना। बहुत कम लोगों के लिए ऑर्गेनाइज करना थोड़ा सा कठिन होता है हम लोगों को, है ना।
सर,
थैंक यू सर।
आपसे एक रिक्वेस्ट था सर।
जी जी,
ये कह रहे हैं ना कि आप जो ये रिपीट सेशन के लिए अभी बताए ना, तो वो जरा इन लोगों के एग्जाम खत्म होने के बाद कीजिएगा तो बहुत अच्छा होगा।
एग्जाम कब है?
क्योंकि काफी स्टूडेंट का सर चल रहा है अभी।
जी जी, अच्छा, ऑलरेडी।
जी जी जी, बिल्कुल बिल्कुल।
अच्छा अच्छा, तो वो कब तक खत्म हो जाएगा?
सर वो खत्म हो जाएगा कुछ लगभग 27 को।
ओके, ठीक है, तो 27 के बाद कर लेंगे हम लोग।
जी 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 सर,
27 के बाद हम लोग कर
थैंक यू।
लेंगे। नहीं, वो इज वेरी वैल्यूएबल टाइम टू गाइड यू पीपल, है ना। और पूरा जो, इनफैक्ट ये पूरा जो एफर्ट है, दैट इज टू इम्प्रूव द स्टैंडर्ड ऑफ लॉयरिंग इन झारखंड। एंड संजीव के बारे में हम बता चुके हैं, जो लोग पहले अटेंड किए हैं। ही इज़ बेसिकली फ्रॉम झारखंड, In fact, his okay, should I say that or shouldn't I say that, Sanjeev? चलिए अब बोल देते हैं, ऐसा भी छुपाना क्या है. He is a humble man. He doesn't speak this. लेकिन his grandfather was the chief minister of Bihar Jharkhand combined, and he's basically from Jharkhand. तो कृष्ण वल्लभ सहाय जो थे हमारे भूतपूर्व मुख्यमंत्री, इनके पौत्र हैं. और ये यहाँ से हजारीबाग से जाकर के, रहने वाले हजारीबाग के हैं, हजारीबाग से जाकर के और वहाँ पे दिल्ली में एक अच्छा नाम बनाया है अपना, और काफी सक्सेसफुल लॉयर है. और हम लोग संजीव यू ऑन म्यूट. आप म्यूट, आपका साउंड नहीं आ रहा. अच्छा, जब तक वो ठीक कर रहे हैं. टू शो में भी बढ़िया बैकग्राउंड से रही है, आपको मेहनत करना पड़ेगा, और अगर आप मेहनत कीजिएगा तो बहुत छोटे लेवल से भी बहुत ऊंचा है. क्योंकि संजीव का बैकग्राउंड तो बहुत स्ट्रांग है, लेकिन तो द एंटायर आइडिया इज टू improve the standard of lawyering and to enable the newly enrolled advocates and the law students कि ये gestation period जो होता है, जिस दौरान प्रैक्टिस सीखते हैं, लॉयर बनते हैं, वो gestation period कम हो जाए, है ना, जितना कम हो सके, so that you people are able to conduct cases on your own, जितना जल्दी हो सके. And that is not rocket technology. ये कोई रॉकेट टेक्नोलॉजी नहीं है. ये जरा सा फोकस और जरा सा आपका एफर्ट, वन पॉइंटेड एफर्ट कि भाई ये करना है तो करना है, और ये आप लोगों को बड़ा लाभ पहुंचाएगा. और हम लोग प्रयास कर रहे हैं, 2-3 प्रोग्राम हम लोग लेकर के बढ़ेंगे आगे, है ना. एक तो जैसा पहले भी हम बता चुके हैं कि एक न्यू लॉयर्स ट्रेनिंग हम लोग करवाने की कोशिश करेंगे, जिसमें कि एफिडेविट बनाने से केस तक जितना भी डिटेल हो सके, है ना, वो हम लोग कोशिश करेंगे आप लोगों को बताने का. कैसे होता है ये सारा चीज़ हम लोग प्रयास करेंगे आपको बताने का. इसके लिए जो लोग इंटरेस्टेड हैं उन लोगों को भी हम लोग जहाँ तक संभव हो वो गाइडेंस देने का प्रयास करेंगे. क्योंकि इंस्टीट्यूट्स है, कोचिंग इंस्टीट्यूट्स, वो बहुत कम है, और जो है उसमें से कितने इंस्टीट्यूट्स अच्छे हैं, कितने ये कह पाना अभी हमारे लिए संभव नहीं है. और हमको, है ना, तो बहुत सारे लोग चले जाते हैं, दिल्ली चले जाते हैं, या आपको इलाहाबाद चले जाते हैं कोचिंग के लिए, और वहाँ पे बहुत सारा पैसा, है ना. तो we hope that we are able to provide some services right at your doorstep, online, virtually, so that आप लोग सबको फायदा हो. यही है आइडिया. Now let us see. Sanjeev is unable to connect, I suppose. Visually, so he was there. Visually, he was here. Rajneesh. Yes.
Sure, I'll join from other system. There's a problem here.
Okay.
Give me that. Sorry. So I would hear you all. I think all my 3 systems suddenly failed. I don't know what happened to it.
दिल्ली में इंटरनेट सिस्टम जो है हम लोगों से थोड़ा सा लगता है कि पीछे.
You know, it is always that at the last moment it has to fail. That's all it is, I can say.
And because of the
नाटक कर लिया, उसमें कोई प्रॉब्लम नहीं थी. ये तो मेरा just
yes.
हाँ.
ठीक है, take your time to set up.
No, I think suddenly it framed. So, but that's fine. We can start now.
Okay.
But, I'm sure my colleague will keep on looking at it and find a solution to the problem, whatever it is. But, let's start with it.
Okay.
So, Rajneesh, as discussed with you, what we have done is that we are doing it in two parts. Okay.
Yes.
So the first part we will try to cover is Hindu Marriage Act, Hindu Adoption and Maintenance Act, Special Marriage Act, CrPC 125, Divorce Act, and Parsi Marriage Act. Okay? In the second part, we will cover the domestic violence, Muslim law, and maintenance and welfare of the senior citizen. Okay, because the DV Act and this maintenance for senior citizen, they are very elaborate act in itself. Okay, so that will take our time. So that will take time a little bit. So we'll do it that way. Is it all right?
हाँ, it's perfect. It's perfect for all of us, I suppose. बाकी लोगों के लिए हाँ. अच्छा सच्ची.
Understand why I selected like this is that when we do this 6 acts or whatever, that Hindu Marriage Act, Hindu Adoption Act, Parsi Special Marriage Act, and Christian, that is Indian Divorce Act, primarily they are all same.
Yeah.
Okay. On prima material, the way the law is formulated. CrPC is a secular law in itself. A true example, what you can say of the Uniform Civil Code kind situation. On the other hand, Muslim law, as it has evolved in itself, it will require some time. You will remember Sabanu's case,
Yes.
case and all. So we'll have to do some justice with that.
Yes.
Okay, so that is there. And then in DV in itself will require some time. And finally, definitely because we are doing maintenance, so I thought that instead of confining it till here, we should also include the Senior Citizens Act.
Yes, we should. Very true.
Because itself is a very nice code.
Sanjiv,
yes.
Is there some problem with the sound? बाकी लोगों को थोड़ा सा इको कर रहा है क्या?
No, sir.
इको नहीं कर रहा ना?
No, sir.
Okay, perfect. So sorry, Sanjiv.
So we'll bear with it. Today I'm doing from the iPad. So, we'll have some hiccups, whatever. I'll put the other system also on place so that, we don't have a situation. But just to, give the... Can you put me a sentence break? Put me in the sentence break. That's always better. So, Rajesh, so friends, let's start with our topic, and more I will call it a debate, because today I'll invite more questions, because, the issues will be very limited, and what I'll try to do is that I'll converge the entire law into one. How there will be a harmony in entire law of maintenance, that's how we'll deal with the situation, all the cases. But that when we got independence, at that time, we used to say that there were 4 golden acts were passed, which was called Hindu Code Bills. Now, Hindu Code Bill, which was passed in 1955-56, which is Hindu Marriage Act, Hindu Succession Act, Hindu Minority and Guardians Act, and Hindu Adoption and Maintenance Act. So these 4 acts were passed under definitely the supervision of the father of our constitution, B.R. Ambedkar. This was aimed to unify the law pertaining to Hindu customary law, which was prevalent all over India, but because it was a customary law, there was no uniform code and it remained segregated, So the framer of the constitution thought to unify the country, it is first that you unify the law. And that's why your Hindu Code Bill came. And we have these 4 acts which is in place, where we will deal today for our purpose. It will be only Hindu Marriage Act and Hindu Adoption and Maintenance Act, and other acts we'll see separately sometime. Now, what is maintenance? Our mood topic today is maintenance. Okay. Maintenance is of 2 forms. One is maintenance pendente light, and one is permanent eliminate. Maintenance pendente light is what is entry maintenance. And permanent eliminate is you should get a final maintenance. Now, maintenance is primarily a financial assistance which is given to the spouse or the dependent. Let's put the word dependent, because it has the dependent has a much wider ambit than spouse, who is unable to maintain himself or herself. in the same status and capacity which he or she was enjoying. And the person with whom this person was living or was dependent upon, he has a duty to perform and maintain that person who is presently in destitution. So that is maintenance. Simple term, financial assistance. Provided to a person who is in financial destitution, who is not able to financially support themselves. And this is the concept of maintenance. And why should we grant maintenance? Important. Because it says maintenance is granted to maintain the same standard of living of the spouse which he or she enjoyed when he or she was living in the matrimonial relationship. So the reason is that the husband, okay, no worry, when it connects then you tell me. No, start from here, no problem. I'll stop it once you start. Okay, so the maintenance, as I said, to be granted is to have the same standard of living. And that's what is maintenance. So two aspects, it needs financial assistance and of the same standard and status which I was enjoying. Now, maintenance is not a new in Indian law. If you see Mitaksha, Manu, Brihaspati, all have said in unison actually three parts of it. A, it is the pious duty of a Hindu to provide to his wife, minor children, infirm and aged parents. And it also says at the same time that any who does the charity to the outside world but does not provide for his own family, he suffers and he is incarcerated to hell. But that is mythological. So we say hell and they put it like this: either you taste honey or you go to hell. So if you provide maintenance to your own family and the needy first, that is your first obligation. And then comes anyone else. So charity should begin at home, as we say now. We always say charity should begin at home. So that's what Hindu concept was. And this is what Mitaksha, Manu, Brihaspati, as I Paras Diwan in his celebrated book Modern Hindu Law has repeated it many, many times over. So coming to this, that we can see the historical perspective, as I said. Now let's come to the codified law. Take this out. So yeah, Rajesh, am I audible now?
Yes, perfect.
Okay. So now, what is the codified law? Let's first see the Hindu Marriage Act. Now, if you see Hindu Marriage Act, there are three sections which is very relevant for grant of maintenance, and one section for execution and one section for appeal. Now, appeal section has become redundant by virtue of your family code coming, so I'll not touch that at this point. So there are four sections only we see: 25, 24, 25, 26, and 28A. Now, what is section 24? Section 24 says it is maintenance pendentalite. Now, as I told you, maintenance pendentalite is an interim maintenance. Interim maintenance means a maintenance which you are awarded when your petition or case is pending. So I file a case in the court. When I go to the court, I file a case. I request the court, and we know in Indian system, a case takes years and years to be decided finally, adjudicated finally. It may take 10 years. An appeal, if you add, it may take another 5 years. So now for 10 years, 5 years, 10 years, or 15 years, how do you expect that this person will provide for himself or herself who is already in destitution? So the concept came in was interim maintenance. That while the petition is pending, you will be entitled for maintenance. And that is 24. It primarily postulates, if you can say it, it's some 5 parts. A, it can be given by either Hindu for wife or husband. Okay, that is 1. 2, the person who asks maintenance should not have independent income sufficient to sustain and provide for himself or herself. 3, that person in financial destitution has to move an application. 4, the court, after considering the reasonable expectation and wants and needs of this needy person, and keeping other factors like what this person was enjoying when this person, say this girl, lady, was enjoying when she was living with her husband. So keeping these 2 factors, what is her reasonable want and what kind of lifestyle she was enjoying when she was staying with her husband. This is 4th factor, 4th criteria. 5th, also that if she is earning, then how much she is earning and how much her husband is earning. These are the 5 ingredients to grant maintenance. I'll repeat this because this comes universally everywhere. A, husband or wife both are entitled for maintenance. B, the husband or wife should be in financial destitution, means they're not able to financially support themselves. C, the husband or wife has to make an application for a grant of maintenance. D, the court will take 3 factors into consideration. 1, reasonable want, a need. 2, the kind of lifestyle she was enjoying. And 3, what is her income and her husband's income. Keeping this 3 criteria, the court will grant maintenance. That is D. Now what is last? The maintenance ordinarily should be granted from the date of application. So if you keep this 5 principle in your mind, your maintenance law is clear. Now, based on this, definitely there is another provision in section 24 that it should be decided within 60 days. Now, this is in India, there are many provisions like this that it has to be decided in 60 days, 30 days, like Order 39 Rule 3A says 30 days, or 3 years back. So, these 5 factors we will consider and see how it is getting replicated everywhere. Okay. When we talk about this, first we'll see this, leave it, don't worry, okay. So first, that is section 24. First we'll see the sections and then we'll come to the implementation or interpretation of those sections, okay. So the second section which comes into play is section 25. Section 24, as you see, my friends, it was interim maintenance, correct? Section 25 is permanent maintenance. Now, permanent maintenance means when the case is finally decided, you are entitled for permanent maintenance. Now, here, the qualification almost remains the same, except one thing changes. So, 4 things remains constant. A, say wife is going asking for permanent maintenance. So, A, wife is in destitution. B, she makes an application. C, the court considers the 3 factors: reasonable want, standard of living, and income of both the parties. Considering this, the court grants maintenance. How 2 things are different in section 25? That please note it. A, in section 25, unless until a decree is passed, because the prerequisite of section 25 is passing of a decree. So unless until a decree is passed, you don't get maintenance under section 25. I'll come to this, what does passing of a decree means later. Second thing, what it requires is, differences between the section 24 and 25 is, section 24 says you have to pay maintenance monthly. But section 25 postulates gross sum. It can be periodic. So in section 25, there's no strict requirement that it has to be paid monthly. Okay, so these 2 sections primarily will be used for maintenance in every proceeding in the divorce petition. So what happens is, okay, there's another section or a child, correct? But section 26 also postulates three things: maintenance and education to be granted to the child. So options under Hindu Marriage Act. A, under section 24, we ask for maintenance. So now these are the three provisions. The important part is now that when we say, are you saying something? No. So important part is now that when we talk about this, that grant of maintenance and permanent maintenance, as we say under section 26 also, it's not that once the court has made an order, the court becomes functus officio. Functus officio means that the court cannot perform any further act thereupon or therefrom. It is not that. The court still is in session to rescind or modify this order which has been passed either under 24, 25 or 24 and 25, not 26. Now, what is this situation where the court can modify or rescind? Change circumstances. Say where the wife starts earning, or B, where the husband has lost everything, got disability or infirmity or things like that. So change circumstances. 3, if the spouse has converted and loses to be Hindu any longer. So religion, and no longer she or he is a Hindu, then he or she is not entitled for maintenance. This is the primary law under section 24, 25 and 26 of the Hindu Marriage Act. Okay. Now the whole thing under Hindu Marriage Act, many questions will come and we'll deal with it. But first I thought, let me do the statutory provisions first. Because keep in mind, my friends, the question will come whether a divorced wife is entitled to be maintenance, whether an illegitimate son is entitled for maintenance, illegitimate daughter is entitled for maintenance, major daughter who has attained majority is entitled. There will be many questions which will come. But what we'll do is we'll do the sections first, and then we will come to the interpretation and application of law. As we say that we have 3 primary provisions: Hindu Marriage Act, Hindu Adoption and Maintenance Act, and 125 CrPC. Parsi Act and Special Marriage Act, Parsi Special Marriage Act, and the Divorce Act, which is the Christian Act, they are primarily on the same line of Hindu Marriage Act. They differ a little bit here and there. Like Special Marriage Act, only a wife can ask for maintenance. Under Hindu Marriage Act, husband and wife both can ask for maintenance. So there are minor differences, but primarily the law remains the same. Okay. Food, clothing, residence, education, medical requirements, and treatments. So it covers, section 18 says who is entitled for maintenance. Section 18, 19, 20. They say who is entitled for maintenance. 23 says what is the quantum of maintenance, how you will assess the quantum of maintenance. And that's how it is. So now section 18, as you would say, one thing is important under HMA, friends. Remember, in Hindu Marriage Act, both husband under HMA, only, and that's the difference. Okay. Now in this, as we say from section 3, wife can ask for a residence separately from her husband. Now, how can she ask for a residence separately from her husband? Where she, for a justifiable reason and cause, is not able to stay with her husband. What is justifiable reason then come? You know, law is very interesting. Like one person said, law is basic common sense. And when you hear a law, the question comes automatically from the law, flows from it. Like I said, wife is entitled for a residence. The question is under what circumstances? So circumstances when she has a reasonable cause to stay away from husband. Immediately question comes, what is reasonable cause? Now reasonable cause is where the husband is committing cruelty, the husband has deserted her, husband is having a mistress or a concubine, husband has changed his religion. So these are illustrative. But these are the grounds where wife is entitled for separate residence. And definitely she is entitled for maintenance also under the same situation. Not only residence, but yes, residence was a very, very important thing because Hindu Marriage Act did not postulate residence. 125 did not postulate residence. All the customary laws, as you will see, Parsi Act, Special Marriage Act, Indian Divorce Act, none of them contemplated residence. This was the only act which contemplated residence. Definitely now we have a Domestic Violence Act, we'll deal with it separately. So, Section 18(1) says a wife is entitled for maintenance. But at the same time, the Section 18(2) puts an embargo on the wife that she will not be entitled for maintenance if she is unchaste or she ceases to be Hindu. So because it's a Hindu law, any kind of marriage associated chastity is a very, very important thing. Virtual Hindu Marriage Act Section 5. A marriage which is void ab initio or is a nullity ipso jure, then that wife is not entitled for maintenance under Hama. So important is a valid marriage. That's a prerequisite under Hindu Adoption and Maintenance Act. Definitely there are some conflicts which is there between Bombay High Court, Delhi High Court, Andhra High Court. We'll come to that and we'll deal with it. But primarily that is the law. But mark it, when we'll come to section 125, then I'll show you the difference between these two sections and how they differ with each other. Okay. Once you say that, then the situation is section 19. Maintenance of a widowed daughter-in-law. Now this is very, very important. Widowed daughter-in-law is actually entitled for maintenance even definitely widow means the husband has passed away, but then she is entitled for her maintenance from the state of her husband, or definitely she can also ask from her father-in-law and father and mother, that's different, but she is entitled for maintenance from her state of her husband and from her father-in-law. That is important. So that is a very nice safeguard it has been created. Means that a widow daughter or widow wife will be entitled for financial assistance from her father-in-law. And she definitely has a safeguard against the husband's state, which has been inherited under co-partnery by the father and by the father-in-law and the mother-in-law and whatever. So this is there a protection to the widow also. So it's not only a married wife, but a widow also is entitled for maintenance. So next term comes is Section 20. Now Section 20 is very important. Hindu Marriage Act, as you saw, that Hindu Marriage Act postulates that a dispute is between husband and wife. The moment it's a dispute between husband and wife, then the children from the wedlock has has to be a legitimate child. But there can be cases where the illegitimate child, whether son or daughter, then what happens? Because they can't come under Hindu Marriage Act. So is section 20 of the Hindu Adoption and Maintenance Act. It says that a Hindu is bound to maintain his and her legitimate or illegitimate children. And the legitimate and illegitimate children can also claim maintenance from his or her father. Now here there is an important thing. They say a minor illegitimate or legitimate son. But in case of daughter, it says unmarried daughter. So see the difference. A son can ask till the age of majority. A daughter can ask till she is unmarried or financially capable. Now definitely Bombay High Court in 2014, Delhi High Court in ad hoc manner, they are giving some kind of maintenance to the major son, but still the law needs to evolve. In fact, the legislation has to modify now. Because in 1956, 18-year-old son would actually start working. In 2022, 18-year, you are actually out of school. You need money. And in fact, that's the time when you need money most for higher education. So this part of section 20 actually needs a legislative amendment. Because what is happening is there's a selective interpretation of this section. Like Bombay High Court in 2014 says that, a major son will be entitled till he is prosecuting his education for his education. Good enough, provide him for his education, but what will he eat, what he will wear, where he will sleep, you have not kept that. In Delhi High Court, what the judge did was that major son is not entitled for. So increase the quantum of wife's maintenance is ad hoc by 15,000. So that part of the child's expenditure is covered. There's other judgment where they say specifically only education to be taken care of become major. Now this is too ad hoc. The situation has changed wholly. The law needs an amendment. In fact, I will actually request my friends in the college to write to Law Commission. One of you should formulate a very nice question and send it to Law Commission. I'm sure you people know what Law Commission is. Law Parliament for amendment of or repeal of any act or laws in the country. But definitely most iconic, if some Rajesh Pandey will know that most iconic Law Commission report was 14th Law Commission, and then by Sitalwad and Justice Chagla, and definitely 1980 Law Commission by Gajendra H.R. Khanna. These are the two law commissions iconic. That I'm sure Rajesh Pandey will tell you sometime later. But as a aspiring lawyer or a law student, you should write to the Law Commission that consider this. Now, once we have tested section 20, so comes section 20. As would say that section 18, 19, 20, they all talked about who is financially dependent: wife, son, daughter, illegitimate son, illegitimate daughter, infirm parents, old parents, and things like that. So what is dependent? Section 21 defines dependent. For the purpose, it means father, mother, widow who has not remarried. Very interesting. I'm sure you, my friends, must have read, if that has been taught in your thing. And who are the first class legal heirs? Son, son, son. Sons predeceased, sons, son predeceased, son, son, son. 3 generation, 4th generation, you go down. Same is the language which you will find in section 21, clause 4 for son and clause Roman 5 for daughters. And the same way you will find for widowed daughter or widow of a son. So, very important that at least till 3 generations, great granddaughter, great grandson, great granddaughter-in-law, they all are protected under this act. So, Pristine Act, that's why they say they were golden 4 acts of 1955. Definitely at that time there was a lot of resentment. Now today we read as a lawyer, we all must be reading this hijab ban, whether it's good or bad. We can have a debate, legal debate sometimes later. Similarly, what was the debate at that time? Many Hindu religious preachers, they thought that it's an infringement to their customary right. There's a dilution of their rights. But today, I'll tell you, because of these acts, all the Hindus have been protected. All Hindus have been protected on their maintenance. And in fact, when we will touch Muslim law, we'll see how Savano's judgment was one unique judgment passed by Honorable Supreme Court, overturned by Parliament by an act, and how then in Rashid Latifi, the court interpreted Section 3 and Section 4 of that act to give a larger perspective. So, Civil Code, I'll actually come to that sometimes, Article 44, and we'll see that this is important part. Here, everyone is protected till 3 generations. They are entitled for maintenance. And you cannot maintenance. Because Section 22 at the same time says that dependency, it will relate to the property of inheritance. And we will see Section 6 CrPC 3 property sometimes. I'm sure you will find an able speaker on Hindu Succession Act section sometime. And only 3 sections are there, Section 6, 8, and 14, which needs interpretation in that section. But relatedly, it has to be done very, very nicely. So, CrPC 3 properties. Now they have linked it that you are bound to provide. You cannot escape. The moment you have inherited the property, you are bound to provide for that. So that is Section 22. Then comes your Section 23. Now we all talked who all will be entitled for maintenance. We all talked about this, that in case the husband is not there, still the state is responsible. But the question is, what is the quantum? How do you identify how much we should give as a maintenance? And that is done very nicely in Section 23 of the section Hindu Adoption and Maintenance Act. Section 23 is of HAMA, which says what are the criteria we should consideration. It is A to G. Which are the criteria laid down? And this is, the court says that ordinarily we should keep these factors into consideration while grant of maintenance. Now put it in short words, definitely. A, status of the parties. As I said, the kind of lifestyle they were living. Status of the parties. Because friends, when you will come into law, what you will face is a funny situation. When you will defend the person who has moved the application, they say you moved an application on behalf of the wife. So the wife will claim that she is a pauper and a destitute, and her husband is the richest person walking on earth. Okay, this is the application you will make. At the same time, the lawyer for the husband will say, may be good, but today I've lost everything. And in fact, my wife is earning and doing very well in an informal sector. Now there's a conflict. When the wife says, I am pauper, my husband is the richest person walking on earth, and husband says, I am pauper, my wife is the richest. Now, how do you assess who is telling the truth? So, status of the parties. We look back that before coming to court, what was the status of these two parties? What was the reasonable wants? Second is what is the reasonable wants of the person who has come to this court? 3, what is the factors for her to live separately to ask for residence? 4th, what are the kind of properties both the parties own? What is the income both the parties are drawing? How many are the persons dependent? Degree of relationship, past relationship, these are all their social factors. But important is now what? Income, what they were earning. Property, what they have. Kind of lifestyle they were living. Social status they were enjoying. Number of dependents. We'll come to one judgment now. And this judgment has laid down the law. That is Rajneesh versus Neha by Justice Indu Malhotra of Supreme Court. That is the judgment which every lawyer should now read. Because that judgment actually interprets every law of maintenance and says what should be not done. Grade who can ask for maintenance, under what circumstances you can ask for maintenance, what is the quantum of maintenance to be granted, from when it has to be granted, how that order has to be enforced, execution, judge, penalty, contempt, everything it lays down. So that judgment is very, very important for everyone to, even for academic purpose. It's only 39-page judgment followed by 3 affidavits, income affidavits, affidavit for non-agrarian, affidavit for agrarian means who has done agricultural income, and affidavit for state of Meghalaya. Okay, so 3 affidavits are required to be filed. Okay. So Rajneesh Neha's judgment is important for the purposes of understanding how the quantum of maintenance has to be assessed. Now, this is the one part where most of the law has been written. We can read Bharat Hegde of Delhi High Court. We can read Manmohan Kohli of Delhi High Court. There are many judgments of Supreme Court. Definitely, we have Jasbir Kaur 1997 of Supreme Court. And there are many judgments. Because as I say, inherently, we all conceal our income. Whatever we do. Okay. So, the question was, how do we say what is the criteria to assess the income? And these 5 criteria, there are many other criteria. In fact, the court would go on to say, after reading this law further, they would say not only this, how many holidays you have taken, including international holidays, your mode of travel. Do you travel by flight? You travel by train? Or you travel by private car? Or whatever mode of travel. Your place of hotel of stay, where do you stay? Your credit card, what kind of spending is there? Your bank statement, what kind of money is there lying on in your bank? In fact, to the extent what kind of watch you are wearing, what kind of clothes you are wearing, everything is considered. In fact, I just remember a very interesting incident. I remember you must have seen Mungeri Lal ke Haseen Sabne was that there was that time Mungeri Lal was that Raghuveer Yadav. So I was doing the case for his wife. And Raghuveer Yadav, such a brilliant actor, it was Jabalpur High Court. He would actually come to court in a bathroom slipper, wearing a pajama and a kurta. And that was a completely tattered and torn pajama and kurta. And he would pretend so beautifully that the judge would believe that he has no money. We kept on saying, Lord, he is pretending. But he was a brilliant actor. And he would say, yes, I did Mungeri Lal ke Haseen Sabne, but जनाब वो तो एक ही था. आपको पता है कि इंडस्ट्री में एक पहला तो फ्री का करना पड़ता है. And he would get away. He actually got away. So, However, can I take a 5 seconds pause? My colleague is saying there's some issue.
Yes.
Taking a 5 minutes.
Yes. Please go ahead. I hope you guys are following it up properly. आप सब बढ़िया से सुन रहे हैं मेरे ख्याल से और सब समझ रहे हैं ना?
जी सर।
थोड़ा सा ध्यान रखना है और कुछ नोट डाउन करते जाना है। जो इम्पोर्टेंट जजमेंट्स बोलते हैं ना सर, वो इम्पोर्टेंट जजमेंट्स को नोट कर लीजिएगा।
ओके सर।
है ना? और जो सेक्शंस वगैरह बता रहे हैं वो नोट कर लीजिएगा, फिर उसके रेफरेंस में पढ़िएगा। वो बेयर एक्ट है ना, क्योंकि तो वो सारा बेयर एक्ट को जब पढ़िएगा तो उसमें ज्यादा टाइम लगेगा। जो रेलेवेंट सेक्शंस बता देंगे सर, उसको पढ़िएगा तो कम समय लगेगा और ज्यादा आसानी से समझ पाइएगा जो कंटेंट है।
Yes, so I'm there. No, Rajesh, you actually said it rightly, that if you can make a note, it will be impressive, because, so I and my colleague Abhay, he's there with me, but he has worked the most, I have worked the least, but we have to work good 10-20 hours to prepare our lecture also. So you people should note down what I'm saying. Because it will be, what we are speaking is after decent amount of research and complete understanding of the law. Okay. So, back to this, that even if you, though hindsight, I cited that issue of, Raghuveer Yadav, but court has to look into various criterias to assess the quantum. What is number of dependent? Number of dependent is, say in a family, mother, father, and 2 children. Husband, number of dependent is 3. In fact, there is a judgment of Delhi High Court. Justice Vikramjit Singh, he said we should treat it like a pie. Pie means a cake. And we should divide into the number of dependent. And 1 extra share for the person who's earning or working. Now, how it is there is that, say a family is husband, wife, and 2 children. So 4 shares. 1 share extra for the husband who's working or earning. So this cake will be divided into 5 parts. 2 will go to the husband, rest 3 will go to the wife and the children. So this judgment also was considered long time. Definitely now with this Rajneesh Neha, it has been overruled. But this held forth for a long time, where the court said, say you are earning 100 rupees and you are 4 members. So you divide into 5 parts. 20, 20, 20 each. The husband will get 40. The mother and the children will get 60. But this whole, and like, Indian Act, Divorce Act at that time said 1/5. That was also there. Even worse, when you read section 125 of the CrPC, it was 500 rupees only. Up to 500 rupees. So from up to 500 to 1/5 to have a complete equals thing that, make it a cake and a pie, we have come to the stage now where we are matured enough to say reasonable want. And what Rajneesh Neha says reasonable want is that it should not be excessive, that you are living in luxury, but it should not be so less that you are in not penury, but you are living in a difficult financial situation. So just that you can live comfortably, that's all it should be provided. It's not an additional undue enrichment. So that is quantum of maintenance to be granted, and that quantum of maintenance to be granted has to be assessed on basis of these criteria, as I was reading section 23 of the Hindu Adoption and Maintenance Act, also when we will read about Rajneesh Neha's 3 affidavit and many other judgments which says what are the criteria to be laid out. And we did Hindu Adoption and Hindu Marriage Act. This completes Hindu Adoption and Maintenance Act. Now we'll see what is Section 125 of the CrPC. As I told you, no, let me do the 3 acts, which is very, very simple. So, Special Marriage Act. Now, Special Marriage Act, everything remains the same, except one, that only wife can ask for maintenance there. Okay? At the same time, and which is section, this is your entry maintenance, section 37 is the permanent maintenance. Okay. Similarly, Parsi Act. Now, Parsi Act is what? You have section 39, 40, and 41. Section 39, maintenance pendant line, akin to section 24 of the HMA. Same. Permanent alimony, section 40, same as HMA. But here you have section 41 in Parsi Act, which is payment can be made to the wife or the trustee. Now, really, we have to see why a trustee or a guardian needs to be appointed. But that is there. What similarly, if you see Indian Divorce Act, it is section 36, 37, and 38. Same line as HMA. Okay. So the only difference what you can see is that in these cases, like in the Indian Divorce Act, it can be a grant of maintenance monthly or weekly. In other cases, it is monthly. But leave that frills apart now. Everywhere it is universally, it is monthly. So I'm not going to that frills now. So understand that Indian Divorce Act, Hindu Marriage Act is almost same line. Okay. Special Marriage Act only differs to the extent that it's only a wife who can ask for and not the husband. So we leave that. Sections, I'm sure I told you, but either way, sections you can find from anywhere. Come to section 125 of the CrPC then. 125 of the CrPC is actually the first secular law created by India in terms of maintenance. This law of section 125 is an aberration or unique to criminal law. The Criminal Procedure Code, it provides like CPC, Civil Procedure Code, it provides the procedure for civil trial. This was incorporated. Criminal code can enforce that maintenance should be granted. And if you don't give, you will be. Market friend, when we're reading HMA, HAMA, Special Marriage Act, they have not specifically talked about imprisonment. They have not talked about magistrate. But here, the powers are different. And you will get when you will read section 3 and subsection 3 and subsection 4 of the 125 of CrPC, that you can go to jail for every default, you will go to jail. And it will be executed by way of warrant. So they realized that we have made good acts and law, but enforceability has become a problem. Enforceability is even today a problem. But in fact, if you read the live law and whatever, Justice Ajay Rastogi has lamented as latest as in January 2022 and says, I remember Privy Council saying that in India, that's the case, other generation executes the case order. Well, and this holds true even today. So this was the problem in India. It's a bane till today. And that's why section 125 was created as a special procedure in a criminal environment. Until long, it was section only 500. Till finally they amended it in 2007. I think they amended section 125. So they amended in section 2 because 2000 itself, the judgment started coming in from Supreme Court saying that, 2,500 was in 1973, which was a, huge money at that time. But today it's irrelevant. You can't have a bar. Section 125, what it says? It says person having sufficient means neglects or refuses to maintain his wife. Not only wife, son, whether illegitimate or legitimate, but minor son, legitimate or illegitimate, unmarried daughter, or her mother or father. So now this became all comprehensive. But here you'll find one thing interesting: husband is missing. Like Special Marriage Act, husband is missing. Or Hindu Adoption and Maintenance Act, husband is missing. Husband cannot come here. Husband up till now can come under only one provision, remember. Definitely under Parsi Act and that also come, but otherwise under Hindu Marriage Act. So here you have to provide for wife. Now, who is wife? There's a very nice thing here. Wife also means a divorced wife. And that is very, very important. Turned by the parliament. Parliament has the power to undo any judgment of the Supreme Court. So very poorly done. But a divorced wife is maintenance. The criteria will always remember, friend. She doesn't remarry. She does not, she remains chaste. So this, but here, you see section 125 of the CrPC, we were talking about that a minor child is entitled for. It talks about illegitimate and legitimate both. It talks about mother and father. So now 122 of section 7 of the, okay? So wherever in section 125, 126, 127, you are reading magistrate, then you have to substitute with family act, family court. But here, there are two things very, very important. That if the person is living in adultery, question is, if she is not a legal wife, then what happens? Whether she will be entitled for or not, we'll consider it. Another factor is that not staying with the husband for any reasonable cause, then she will not be entitled for. Now, in fact, a very interesting judgment which came was that where the husband had filed for restitution of the conjugal right under section 11 of the Hindu Marriage Act, 9 of the Hindu Marriage Act, correct. Thank you, Ajay. 9 of the Hindu Marriage Act. So, in that case, it was the case was that once the husband has got the order of restitution of conjugal right and wife is not staying with her, will she be entitled for maintenance? Because now the court has opined that you have to stay and you are not staying. So you are, as a wife, staying away without any reasonable cause. Definitely, the court said that from the date of the order, she will not be entitled for. Which is again, you will understand that these all judgments have been little more in favor of female in their interpretation and application than in favor of men. In fact, rather more in favor of the woman than in favor of men. But that's the way these social legislations have been. And we have to interpret like that. So, as I said, that section 3 provides for the execution of this, that if you breach every month's bill, but at the same time, even if the order, and this is universal, adultery, intent has been over the field. That how we will deal with the conflict was what happens if you get maintenance in one case and you don't get maintenance? Will you get maintenance in other act? Say I am filed for maintenance under section 125 of the CrPC. Will I get maintenance under any other act? One issue. Two, what are the criteria to compute the maintenance? Three, what is the quantum of maintenance? Four, in India, because there's a lot of cases of informal sector where you can hide your income, then how do you quantify the maintenance? Execution, enforcement. So these were the plaguing issues which were facing us. Many judgments. What was the pioneer? Sonis came, Kushum Sharma 1, Kushum Sharma 2, Kushum Sharma 3, Kushum Sharma 4, means there are different generations of cases coming where the court kept on passing income affidavit to be filed. But finally came your Indu Malhotra's judgment, Justice Indu Malhotra's judgment, Rajneesh and Neha. What she did was, she took everything in one quadrant and evaluated every law and effectively have laid down the law for the country. So I can actually say that you have Article 44 of the Constitution of India, which says Uniform Civil Code. Uniform Civil Code, because she has considered the entire gambit of law from the judgment. So first topic it deals with is issue of overlapping jurisdiction. Now, what is overlapping is that where 125 of the CrPC, you can file under Domestic Violence Act, you can file under Hindu Marriage Act or any other special act where you can fall in. So what the court will do? Will the court grant you maintenance in every case, or will the court refuse maintenance in every case except for the first case where you have been given maintenance? There was a conflict. Many times the judges would say, sorry, you've got in one case, we are not going to give you in any other case. So finally the court, Supreme Court has said that in overlapping jurisdiction, you have two things very clear. A, you have a right to file for maintenance under every act. Whatever maintenance you get under one act, adjusted towards the maintenance you have got under another act. Say, assume it's not that I'll get 100 plus 110. I'll get 100 rupees from DV Act and 10 rupees from Hindu Marriage Act. So overlapping jurisdiction also very enthusiastically says that 60 days, 60 days, but Section 3 of the HMA, what are the criteria? Everywhere they were saying reasonable want and expenses, Section 24, 20. But what are the criteria? So Justice Indu Malhotra, after considering, as I told you, Punit Kaur, Kusum Sharma, all the fours, and I said Delhi High Court was only pioneer in this, and it was Justice Midha who did, recently retired, in fact, from High Court, Delhi High Court. So she went through all this income affidavits, what we call, and finally drafted 3 income affidavit, which you'll find at the end of this judgment. That is income affidavit for non-agrarian sector, income affidavit for agrarian sector, and income affidavit for state of Meghalaya. State of Meghalaya has been kept separately because there the entire thing is very different. It's a matriarchal society and many things are different there. The property is owned by the female there. So, that has been kept separately. Now, non-agrarian means like me or you who are working and earning. Agrarian means jo kheti karta hai, agriculture karta hai. So she has made 3 affidavits. Now, under Article 141 of the Constitution of India, she has made it a law that every court in the country has to follow this. That's why I said we have achieved UCC somewhere, Uniform Civil Code. Now, every court, the moment you go to the court with an application for maintenance, you will have to file your income affidavit. And income affidavit requires detailed disclosure of everything. Status, travel, expenditure, car you wear, watch you wear, clothes you wear, everything. And it also says you have to file 3 years at least of your financial documents. 1 year of separation and 1 year from the date of filing of the case. So 3 different sample years you will have to file the documents. Because here there was an anomaly in Kushum Sharma. Kushum Sharma used to say you have to file from the date of marriage. Now if someone's marriage is say 15, so the reasonable thing is to say file it last 3 years. But Kushum Sharma has differed from, Justice Indu Malhotra has differed from there and said 3 years, but 3 sample years. Okay. So this is how uniformity has been brought all over the country, that the moment you file, you have to file your income affidavit. Now the court says, what are the criteria for determining? Same thing will Euclid's theorem, as we call it. It is not a square plus b square, a plus b whole square is a square plus b square plus. What is there is that it requires human discretion and interpretation. Justice Indu Malhotra, writing all, actually puts it in 3 words according to me. A is a discretion and the wisdom of the court. B, it should be granted to reasonable wants and needs of the destitute. C, it should not be excessive or luxurious. So she has not done A plus B is equal to 2. She has not done, Justice Vikramjit says that it is a pie. She has not only said it has to be just reasonable to meet your necessities with dignity. So here it becomes totally a discretion of the court, and as a lawyer, it a good part of your advocacy, that how you convince the court that what is your need. So as a lawyer, you should work here very strongly that to prepare your case. What is the need? Third thing what she says is that whether or an educated wife is entitled for maintenance. Here again, she has been little ambivalent. She says education does not necessarily mean that it's earning. Educational capabilities, that does not mean, or capability to earn does not mean that you are actually earning. That's one part of it. Secondly, in this also field, from Mamta Jaiswal's judgment of, if husband and wife both are not working, then husband has to provide for the wife even if he's not working. The court will presume wages as the earning. But as for maintenance, then he has to prove disability. It remains for wife also, but then these are, as I said, social legislation. The court will interpret always in favor, a little bit in favor of women, and there's no harm in it. But traditionally, it is the men. So she says, a wife earning also, you have to consider that how much she is earning and how much her husband is earning. And that is what section 24 of the HMA also says, that keeping it, now Hindu, from the date when it has to be awarded. So she said it has to be awarded from the date of the application ordinarily, and in exceptional circumstances from the date of order. Why and is not prosecuting the case. The person who is filing the case. So they can be from the date of application. Then she comes to the enforcement part. Now, enforcement, you will see section 28 of the, you will see order 21. Why section 28 of the HMA? A, because it says it can be treated as an order of the. The moment you say this, it becomes an order of the civil court. You have a very important provision of law which comes to your protection. That is order 21 of the CPC, which is execution. So, A, you have a right of execution. B, there's a chances of punishment, section 125 of CrPC. Now understand, these are all universally applied now. So under Hindu Marriage Act also, a person will go to jail for default. So now there is no difference. Earlier it was. Third, the court treats it as a contempt of the court. Fourth, the court can strike off your defense. Fifth, the court can attach your property and sell the property. So they have worked a lot on execution, and there are two unique examples. First one, which I was telling you, we got a maintenance of 1,30,000 rupees per month. Okay, the person refused to pay. The court was passing orders after orders for his presence. To his advantage, COVID happened. 2 years lost. In between, we went to High Court. We came back to the trial court. Finally, we got one hearing before the trial court, and the court directed the DCP to go and arrest him and produce him before the court because he is not coming. He was finally arrested on 31st of December. When he got arrested, that's the time he started paying. So this is the level we have to go. In another case, that was a case where we got a very high quantum of maintenance. So my opposite side was a very famous cardiologist. I'll not take the name here. And I was for the wife, so a very famous doctor. She's the director of a medical hospital in Delhi. She was earning at that time around 2 lakhs per month, and we got a maintenance of additional 2.5 lakhs because the doctor cardiologist was doing very, very well, phenomenally well. Now, the husband who didn't want to pay the money, we asked the court for enforcement. Court said he's not coming, we are dismissing the appeal, let him not come. Now the appeal was dismissed. He has not turned up since then. But what happens? There's no enforcement of that order. So, striking of defense and everything is good, but when do you actually see the color of the money? It becomes very, very difficult. So in India, enforcement, according to, as I told you, the two lacuna which I saw in Indu Sharma's judgment was that still the quantum has been left totally to the discretion of the court. And two part, the court should have done little more. Like I can see one thing. What happens? Now under when you file an appeal under section 34 of the Arbitration Act, the court says first deposit the money, then we'll hear you, or otherwise will not grant you stay. You have the same provision under DRT now. You deposit 50%. You have a similar provision under Employees Provident Fund Act. She should have crafted something there. That the moment an order comes, you have to first ensure the payment or secure the money before proceeding further. So this discretion and the enforcement, which still remains largely to say, these are the only two things where I saw that this Rajneesh Neha's judgment could have done little more than what is required. Okay, so coming to the issue, look, we have covered the entire facet of law. Okay, and primarily, as I said, everything will now culminate into Rajneesh Neha's judgment of Supreme Court. What I'll now say is that I'll leave the field open. You can ask any questions feel like so that I can answer. That will be much better. Now you know the law. This is the law. There's nothing exceptional to it by now. Okay. Rajesh, can we leave it open for people to ask questions?
Yes. जिनको जो क्वेश्चन कुछ पूछना है तो पूछें, वो है ना, किसी को कोई क्वेश्चन है?
Sir, excuse me, sir. Sir, will you please explain the first legal heir in the parental property?
Oh.
Just
ये
there is the parental property. That when we'll do Hindu Succession Act, I'll tell you. But otherwise, first legal heir is defined well there. That who are the legal heirs. So there is a first class legal heir, second class legal heir, agnates, cognates. We'll do it when it comes not required here. But definitely it depends if you are if the father has died, then it is A category, then the mother has died, then there's some other category. So there will be a lot of qualification there. So permit me when you do Hindu Succession Act, I'll clarify your doubts. Okay?
जिस सब्जेक्ट पे लेक्चर हो रहा है ना, उसी सब्जेक्ट से रिलेटेड क्वेश्चंस अगर आप पूछेंगे तो उससे ध्यान जो है वो भटकेगा नहीं, है ना? उसी से संबंधित जो इनको जो क्वेश्चन है वो पूछे।
सर
यस
सर एक क्वेश्चन है सर मेंटेनेंस को लेकर। तो उसमें सर पूछ रहे थे कि जैसे कि मेंटेनेंस एक वाइफ सर जैसे कि केस है वो फाइल करती है, जैसे कि एक वाइफ है वो अर्न करती है 1 लाख रुपीज और जो हस्बैंड है सर वो अर्न करते हैं 5 to 6 लाख रुपीज। तो उसमें सर वो जो वाइफ है वो तो खुद में वो कैपेबल है, क्योंकि बहुत सारे ऐसा घर होता है कि सर कि वो 50,000 में पूरा घर वो चला लेते हैं, लेकिन ये तो एनफ है, खुद में इसको खुद ही खाना है, खुद ही ये मेंटेन करना है, तो 1 लाख रुपए तो सर इसके लिए एनफ है। लेकिन सर जो अगर स्टैंडर्ड ऑफ लिविंग अगर इसको मेंटेन करना है हस्बैंड क्यों, जैसे कि उनके हस्बैंड कमा रहे हैं 4 to 5 लाख, तो सर उसका डेफिनेशन
Rekha, I understood your question. It's simple that wife is earning 1 lakh, husband is earning 5 lakhs. Will she be entitled for maintenance in this case? Dekho, you have a question. 90% now the courts will not grant a maintenance in this situation. They are saying your reasonable wants are fulfilled. Okay. There is nothing called now luxury. As I said, if we had seen Vikramjit Singh's judgment, then yes, you were entitled for, but that judgment is overruled constructively by this Rajneesh Neha. So reasonable want you will not be entitled for. Okay. Or maybe the court at a wisdom will say, okay, fine, give her a litigation expenses of 1 lakh so that she can take care of the litigation expense. That can be done, but maintenance, I doubt the court will grant you.
Okay. सर एक और सिचुएशन है कि सर जैसे एक वाइफ होती है और वो हस्बैंड होते हैं, वो गरीब परिवार से शादी, वो जो हस्बैंड रहती है वो गरीब रहती है और उसका परिवार है कि सब पूरा परिवार 20,000 में वो मतलब वो लाइफ को एक्सपेंड कर लेती थी, और लेकिन उसके हस्बैंड है कि 2 लाख रुपया वो अर्न कर रहे हैं। तो अगर हस्बैंड ये बोले सिचुएशन में कि अगर तुम्हारा पूरा परिवार तो 20,000 में तुम्हारा घर चला जाता था, अब तुमको हम 20,000 दे रहे हैं तुमको मतलब तुम्हारे खुद अकेले के लिए। ओके सर, तो उस सिचुएशन
मैं बता रहा हूँ एक मिनट। राजेश, you were there in Delhi High Court at that time and Justice Sikri was there.
Yes.
You will recollect.
Yes.
So I was representing a lawyer CA. He was a very well-earning CA of a big 4 consulting firm at that time. Okay, and he had written to his wife the same thing in the letter, that you are asking 20,000 and your father earns only 5,000 and runs the house. This line actually bothered him till the entire litigation. I don't know how many cases we had to give, how many times we gave explanation that he wrote it in anger. Justice Sikri wrote in the order that if this is the attitude of the man and he thinks that 20,000 is too big amount, I'm granting 25,000 to this wife. So, Rekha, it's not the status of the wife's family. It is the status of wife's husband. Which
yes, sir.
Okay.
Yes, sir. Thank you, sir.
Any other question?
Yes, sir. I have a few questions regarding this matter. I have a question that where to file these petitions under Hindu Marriage Act, Hindu Adoption and Maintenance Act, and Special Marriage Acts. Whether to file before family courts or magistrate court, under whose jurisdiction the petitioner is residing.
All under family court.
Okay.
All under family court. Now there's no controversy in law. Amina Bhagatram's judgment clarifies this many times over by now. Everything will go to family court. Okay? No other jurisdiction. Okay.
is there any specific or prescribed format for filing the case? I mean to say that in 125 we know the format of the case, but like in domestic violence cases, the format is quite different when we file the case. In such
रवि, मैं बात समझ गया. आप ये कह रहे हो कि भाई is there a specific format like under 125 or we see section 12 of the DV Act, there's a format given. The law is also now well settled that there's no specific format. You can follow that format, you may not follow that format. What is important is that you have filed the petition, that's good enough. Don't follow the format. There's no requirement in law.
You have discussed the Rajneesh versus Neha case, and where has to file affidavit before. So, what should be the matter or the contents the wife should file before filing the case?
No, I could not get it. What you are saying?
In Rajneesh
रवि से पूछिए.
नहीं समझ रहा, मुझे क्वेश्चन वो ब्रेक कर गया वॉइस उनका.
फिर से पूछिए रवि, फिर से पूछिए.
Sir, in Rajneesh versus Neha case, both the parties has to file affidavit along with their petition or WS. So, what should be the contents while filing the case on wife side in affidavit?
No, what is the content? The content is very clear. But the content is provided in the affidavit. You don't have to bother, just read it.
Okay.
Everything is there. You read it and keep on writing.
She has to declare her source of income and so.
Thing she has to declare for the 3 years, as I told you. 1 year before the marriage, 1 year before the separation, and 1 year before the filing of the case. And last 3 years, all the income financial documents. That is your bank statement, ITR, balance sheet, whatever the case may be. Profit and loss account, whatever it may be. So you have to file every document with your power and possession. There's no question of concealment. If you conceal, there's an adverse presumption and which they have laid down under Order 10 and Section 165 of the Evidence Act. Okay.
एक मैसेज.
How does the case stand?
Yes, Amar.
So how does a case stand if the wife turns out to be more educated than the husband? For example, the husband is a graduate and the wife is postgraduate or PhD. How does the case stand there?
There is no, look, very clearly said that education of the wife is not relevant. Earning capacity of the wife is not relevant. What is relevant is she earning, and if so, how much she is earning? Okay.
एक क्वेश्चन मैसेज से आया है संजीव. ये what happens when opposite party doesn't pay the amount?
So इसमें now, as I said, there's a universal law. Okay, because of Rajneesh Neha, the law has been codified and made it universally applicable. तो इसमें तुम्हारी बहुत सारी चीजें हैं. एक तो ये है कि they can be defense can be struck off. Okay, if he is a defendant, if he is a petitioner, then his case can be dismissed. That's one. B, the property can be attached under Order 21 of the CPC because it's a order of a civil court under Section 28 of the HMA, 28A of the HMA rather. He can be sent to jail. Okay, so he can be hauled up for contempt. So there are many options which is there for enforcement.
सर एक और क्वेश्चन सर पूछ रहे सर, एक अगर सर वाइफ है वो अगर वो मेंटेनेंस का केस फाइल करती है तो एक सर होता है CrPC 125, एक सर डोमेस्टिक वायलेंस एक्ट और एक होता है सर हिंदू मैरिज एक्ट जो भी है, और वो सर मतलब 2 महीने का गैप या जितने गैप में वो तीनों अगर वो फाइल कर देती है तो सर उस केस में क्या होगा?
मैंने बताया था राजेश नेहा ने इसको ओवरलैपिंग जुरिसडिक्शन को डिफाइन
यस सर।
किया है। ओवरलैपिंग जुरिसडिक्शन में ये है कि यू विल गेट जजमेंट मेंटेनेंस इन वन and the maintenance in the other case will be adjusted against the first one. So as I told you, I gave you an example that in DV case, assume you got 100 rupees and say in under 125 you got 110. So you will get 10 rupees extra only in the 125.
Okay sir.
Okay.
Thank you sir.
Sir, suppose the judgment has come that the husband has to pay 20,000 per month as per the decision. But suppose after 2 years he got bankrupt or lost the job, then what will be happen about the maintenance?
Dekho, change of circumstances, as you see, is there in every provision of law. You saw section 25(3) says change, 2 says change of provision, change of situation. Section 125(4) also says change of situation.
Okay.
Change of circumstances always.
एक और मैसेज आया है संजीव, एक केस है जिसके बारे में कह रहा है कि एक लेडी है जो अपने हस्बैंड के साथ रहती थी, बाद में दोनों अलग हो गए और हस्बैंड ने दूसरी शादी कर ली है, और वो लेडी जो है वो मैट्रिमोनियल होम में ही रहती है और वहाँ पे कुछ रेंट आता है और उस रेंट से अपना गुजारा करती हैं, परंतु उनको जो है मिला हुआ था 3,000 रुपये पर मंथ का मेंटेनेंस, और उस मेंटेनेंस को उनके हस्बैंड अब देने से मना कर दिए हैं, ये कहते हुए कि वो रेंट से गुजारा करती हैं, जबकि उनका रेंट से पर्याप्त गुजारा नहीं हो पाता है, और उनका बेटा भी लॉयर है।
किनका? हस्बैंड का?
लेडी का। ही इज सपोर्टिंग हिज मदर, बट ये कंडीशन ये है, सर्कमस्टेंसेस ये है।
देखो, इसमें क्या करना होगा कि हस्बैंड अगर नहीं कर रहा है तो उसका प्रॉपर्टी है, प्रॉपर्टी के अगेंस्ट प्रॉपर्टी अटैच करवा लो, और क्या। यू आर लिविंग इन द सेम प्रॉपर्टी, गेट इट अटैच्ड इन योर फेवर।
Attached in his favor, right?
In her favor,
in his favor, right?
Yeah, that's the best way. You will always get the property to yourself. If he is not
And
coming, look, if he is saying that she is getting rent and rent is sufficient, that he has to prove. As long as the order, Rajesh, we know, we read that voidness of an order is not written on the forehead.
Right.
You have to get it set aside by the court.
Right.
So this gentleman can say it is bad and she is earning and I will not pay her 3,000, but till the order lasts, he has to pay.
Right. Okay. Any other question?
Yes, sir. सर सपोज अगर हस्बैंड जो है अगर बीमार रहता है और वो कुछ भी अर्निंग करने के लिए मतलब एलिजिबल नहीं है, तो उसके घर का पूरा खर्च जो है उसके भाई द्वारा या फिर फैमिली मेंबर्स के द्वारा हो रहा है, और उसमें भी वाइफ को अगर मेंटेनेंस चाहिए, तो उस केस में सर क्या होगा?
Where you talking the husband is infirm,
yes sir,
it is totally different. Then he is not doing anything, he is himself become a dependent. Infirmity and indolent or idleness is different. एक हस्बैंड जो बैठा हुआ है काम नहीं कर रहा है, एक वो जो मेडिकली इन्फर्म है काम नहीं कर रहा है, बहुत डिफरेंस है। अगर सोचो कोई मेंटली इन्फर्म है तो क्या होगा? डेफिनेटली ही विल कांट प्रोवाइड।
यस सर, थैंक यू सर।
I think Sanjeev, it's already more than yeah. It is 8:15. It is 8:20. Yeah. So it has been a very long session, and it has been a very interesting session, and it has been a very good lecture with so many case laws and so many references. So I must congratulate you and congratulate all the participants, in fact, that they have had this opportunity to listen to this such a nice lecture. And we are looking forward to the second part of this lecture, which I hope should be very soon.
Yes.
लेकिन वो 27th के बाद, क्योंकि 27th तक कुछ लोगों का एग्जाम चल रहा है।
And then we'll do second week. We'll go after 27th either way. That's perfect.
हाँ, right. It's already 19th now today. Yeah. So thanks a lot for this session.
Thank you.
And
Thank you very much, both of you, sir.
Okay.
Thank you very much, sir.
Okay. Thank you, everyone. Bye.
Thank you.
Thank you, sir.
okay, bye, all of you.
Thank you, sir.
Bye.
Thank you.
Bye, sir.
Thank you, sir.
Okay, bye. Achha, anyone from Jamshedpur? Anyone from Jamshedpur over here? No one. Okay.
No, sir, we are from Ramgarh.
Okay, all of you are from Ramgarh, no?
Ranchi, sir.
Okay, सारे लोग रामगढ़ के हैं?
No, sir. I'm from Ranchi.
No, sir.